Hey, what's up guys? This is an introductory video to copyright law in Singapore. What is copyright? Copyright is a term used to describe a bundle of rights that is granted by a statute in respect of original works and other subject matter created by authors, okay, for a limited period of time and subject to certain exceptions under the Copyright Act in Singapore. Unlike patents, which gives the owner a monopoly and exclusive right to use the patent, copyright is a negative right. In other words, it's to prevent people from copying the original work. It's very important to know the difference between an idea and the expression of an idea. This is very important when dealing with copyright, because copyright only protects the expression of an idea. It does not copyright does not protect the idea in itself. This was laid down in the Singapore Court of Appeal case of Global Yellow Pages Limited and Pro Media Directories. For example, if you create a flowchart on the ideal way that a hotel spa should be managed and run and operated, so you use a computer program to create a flowchart on the spa operations, the way of doing the spa operations, and you upload it to the internet, or you use it in some kind of standard operating procedure book. Now, the idea is how the spa in a hotel should be operated, the ideal way that it should be operated. Copyright does not protect the idea. Copyright only protects the way the idea is expressed. In this case, it is the use of the computer to create the flow chart, which is then uploaded to the internet. So if someone else copies your flow chart created by you and puts it on his website or in his materials for his spa, then there would be an infringement of copyright. But if someone looks at your flow chart and then does a similar flowchart based on your flowchart using the same idea but expressed in a different way. For example, he used different colors, different arrows, different wording, which was paraphrased from your original flowchart. Then there would not be an infringement of copyright, because copyright protects the expression of ideas in an original work, not ideas themselves. Furthermore, copyright protects the skill, labor, and judgment used in creating the expression. In particular, copyright exists in literary, dramatic, musical, and artistic works such as novels, books, plays, musical compositions, paintings, sculptures, and compilations, as well as the subject matter of other works such as sound recordings, films, broadcasts such as this YouTube video you're watching, cable programs, and published editions of work. Additionally, copyright protection is available in respect of live performances and rights management information, such as information identifying the author of a work and the terms and conditions relating to the use of the work. Now, how does copyright arise? Do you need to register it? No. Copyright arises immediately upon creation of the work. There is copyright protection in a work as soon as it is expressed or fixed in a material form, for example, in paper, tape, or film. In relation to literary, dramatic, musical, and artistic works, there must also exist an identifiable author who is a natural person. This principle was laid down in the Singapore Court of Appeal case of Asia Pacific Publishing and Pioneer and Leaders. Unlike patents and trademarks, there are no formal registration requirements. You don't actually have to register your copyright to enjoy the protections under the Copyright Act. In general, copyright subsists in a work or subject matter in Singapore if, number one, the work or subject matter was first published or made in Singapore or in a member country of the Berne Convention or the WTO. Number two, the author of the work or the maker of the subject was a citizen or resident of Singapore, or of a member country of the Berne Convention. You can Google the Berne Convention, or the WTO at the time when the work was first published or made. So thanks for watching this introductory video on copyright. Do stay tuned for subsequent videos.